Mr. Rothfus, the gentleman from Pennsylvania, is recognized for question.
Thank you, Mr. Chairman. Thank you, panel, for being here today, and enjoy this conversation like Congressman Marino. It's like I'm back in law school. I appreciate the comments I've heard about yet another hearing on regulatory issues. I suggest that the reason that we're here again is because the more people learn of how we've empowered unelected elites to micromanage us, the more they want to check on that power. The actions of these elites are resulting in lost coal miner jobs and power plant worker jobs in western Pennsylvania. And the actions of these elites are also threatening the health insurance plans of people in western Pennsylvania, and therefore their access to health care. Criticism of rule by elites is not, of recent vintage. In 1981, President Reagan in his inaugural said that from time to time, we have been tempted to believe that society has become too complex to be managed by self-rule, that government by an elite group is superior to government for, by, and of the people. But if no one among us is capable of governing himself, then who among us has the capacity to govern someone else? I've long had a concern over the abdication by Congress of its constitutional duty to legislate. There's a belief among some that society is just too complex for 535 individuals, 435 here in the House and 100 across the Capitol and the Senate, to come up with legislation necessary for a properly functioning society. I reject that premise. Mr. Gattuso, I'd like to just go over some of the recent regulations that we're seeing coming out and just get your opinion. Do you believe that 535 members of Congress might be able to conclude whether carbon dioxide is an air pollutant under the Clean Air Act?
I think that they are capable of making that decision.
Would Congress be able to take hearings on that issue and make a deliberative decision on that?
I think it can.
Do you believe 535 members of Congress might be able to review the Secretary of Health and Human Services diktat of what must be in every person's health care plan and make a reasoned judgment on whether that's a good idea or not?
Absolutely.
And do you believe that 535 members of Congress have the capacity to determine what a qualified mortgage should be, whether it would require a 10% down payment, a 15% down payment, a 20% down payment?
Not only that, but they're able to decide whether the government can decide that for consumers.
I'd like to ask the professors a little bit about the constitutionality issues. Isn't this really yet a further condition precedent to a regulation becoming effective? It's inchoate in the sense that we have requirements that a regulation should go through, and yet we've established one more requirement in the REINS Act where it will not even become effective until it's been approved by Congress. Can you comment on that, professors?
That is exactly the argument that was made on behalf of the legislative veto in its day, that it was just a device that Congress attached to the Immigration and Nationality Act to be a condition precedent for deportation decisions. And the Supreme Court gave that no weight because it undermined the heart of the bicameralism and presentment requirements. I think the same would be true in this instance.
But when we have legislation that we know is going to be subject to this, can't the Congress be considerate of that? When we delegate, to a regulatory agency to come up with a regulation under REINS, we would know that that's going to come back to the Congress for review.
Well, if I may comment on your previous characterization of this as ruled by elites, I think that the process that 535 members established is actually a pretty sound one. They make some decisions themselves. They leave others to the executive branch through a delegation, and the executive branch's decisions are subject to political accountability because presidents make decisions and they run on their record. And in this instance, President Obama ran on his record of regulation. It was squarely an issue in the last campaign. It was hotly debated on all sides. He was reelected. And I think the people spoke, although not everybody seems to have heeded that message.
Professor Claeys.
So with respect to Professor Levin, I disagree on several points. First, there's a huge difference between Congress being able to stop, there's a huge difference between the legislative veto and the REINS Act. In a legislative veto, Congress is saying we want the administrative process always to go forward, and then we want discretion from one house, both houses, or committee to interject and stop one particular action. There's a huge difference between that set of affairs and another set of affairs where Congress says, even though most of the time rulemaking has advantages, we don't want those advantages to be here because we're so worried about the impact of the economy or the threat to rights. So we want to slow things down, and we want to take ownership of the basic policy choices. And I don't think that any judge who's at all practical or functionalist in the way Professor Levin talks about in his testimony would ignore that difference. And, well, I'll just stop there.
Thank you. Thank you, Mr. Chairman. You go back.
Thank you.